So was Mohori, represented by Ms. Caroline Kituku, made extensive submissions on the issue of the verification of signatures by IMBC and also the quorum of IMBC. We have captured that. The 79th respondent, Kituo Sasheria, represented by Learned Counsel Dr. Kaminwa, also made extensive submissions, and we also have considered the briefs by the Hamisi and Professor David E. Randau, the first and second Hamisi. We have also considered Gautam Bhatia, the third Hamisi, what he told us in his written submissions on the application of the basic structure. Professor Migai Akich, the fourth amicus, also submitted a Hamisi brief, which we have summarized on the issues that they raised. Professor Richard Albert, the fifth Hamisi, we have captured the submissions regarding the issue of the basic structure doctrine. And Professor Yaniv Rosnan, the sixth amicus curiae. Professor Charles Manga Forband, Professor Dr. Adem Abebe, Dr. Duncan Ojuang, John Osogo, and Dr. Rinda Musumba also filed a very extensive Hamisi brief with Dr. Jack Mwimari. The Kenya Human Rights Commission also made some extensive submissions on the basic structure doctrine. I have considered all those submissions for and against the appeal, and as observed, the appeals are predicated on Article 163, 4A of the Constitution, which clothes this court with the jurisdiction to determine appeals from the Court of Appeal on question of interpretation and application of the Constitution. Although the length and length of the pleadings and arguments are summarized, I've touched on several chapters of the Constitution. The common denominator is that they are focused on the interpretation and application of Chapter 16 of the Constitution and how that is to be done. The two superior courts below have traveled and touched all the key provisions of the Constitution. In my view, therefore, this court's jurisdiction is properly seized under that provision of the Constitution. And having set out the issues framed by the court for determination, the 7 issues, I will now proceed to deal with them sequentially. On the basic structure, it is pertinent in the circumstances to point out that the basic structure doctrine, as articulated in the High Court and endorsed by the majority judgment of the Court of Appeal, the sum total of the two decisions being that beyond the 3 stipulated pathways for amending the Constitution provided in Chapter 16, there are certain fundamental features in the 18 chapters of the Constitution that are not amendable without first determining on a case-by-case basis whether a proposed amendment forms part of the basic structure. Further, that any amendment to these particular articles identified as fundamental features of the Constitution would follow a four-sequential process, being civic education, public participation, and collection of views, constituent assembly debates, and a referendum. In effect, the two superior courts below concluded that certain provisions of the Constitution are beyond the reach of enumerated amendment powers stipulated in Chapter 16 of the Constitution. The history of the emergence and evolution of the basic structure doctrine was comprehensively covered in the very detailed judgments of the two courts below. Therefore, I will merely mention some of the key features to place my findings in perspective. The basic structure doctrine first received judicial recognition in 1973 in the Kesavananda case, a decision of the Supreme Court of India. The case concerned a challenge to the state government of Kerala's attempt under two land reform acts to allow state government to acquire privately owned land to fulfill its socio-economic obligations. Subsequently, the Indian Parliament passed the 24th, 25th, and 29th amendments to the Indian Constitution, which in one way or the other shielded Kerala State's land reform acts from being challenged in court. It is in this context that the Supreme Court of India addressed the question of whether there were limits to Parliament's power to amend the Constitution. In a majority judgment of 7 judges with 6 judges dissenting, the Supreme Court of India held that the 24th, 25th, and 29th Constitutional Amendment Acts passed by Parliament, exercising its powers under Article 368 of Constitution of India, were unconstitutional to the extent that they damaged the basic structure of the Constitution. The doctrine places substantive limits on the amendment power by placing the basic features of the Constitution beyond the legislative's power to amend the Constitution. In effect, the Supreme Court of India endorsed the idea that a constitutional amendment can be unconstitutional on substantive grounds. I have recited or restated the provisions of Article 368 of the Indian Constitution, and from that provision, it is clear from its reading that the amendment process under the Constitution of India is exclusively vested in the legislature. This therefore means the amendment process of India's Constitution can be described as falling under the flexible model of amendment powers in the flexible regime dichotomy used to categorize the nature of amendment powers in a given constitution. And for this proposition, I have also read the books by Sakan Ekins and Richard Albert on making, breaking, and changing the constitutions. Subsequently, the basic structure doctrine and the idea of limits of power to amend a constitution have been considered by courts in several jurisdictions across the world and received mixed reception. For example, the basic structure doctrine and its variants have been accepted in Bangladesh, Belize, Colombia, Taiwan, Malaysia, Slovakia, and Peru. While courts in France, Georgia, South Africa, Singapore, Zambia, Uganda, and Tanzania have rejected the doctrine. What this state of play demonstrates, which has been recognized by some of the distinguished scholars as reflected in the various materials cited before us, is that the basic structure doctrine has not yet matured into a universal norm of constitutionalism. And for that, I have referred to the writings by Richard Albert, Maukas, Makize, and Aris Oke. Given that the basic structure doctrine has not matured into universal norm of constitutionalism or a doctrine of general application, courts have adopted the approach of evaluating its fit within their constitutional systems before accepting its applicability in the various jurisdictions where it has been considered. In Kenyan context, this court has already developed an approach which courts are obligated to follow in ascertaining whether to transplant any juridical idea to the Kenyan Constitution in the post-2010 constitutional order. In the vetting board case, this court grappled with the question of the scope and effect of the ouster of the judicial review power of the High Court by a constitutional ouster clause. Whereas the court considered similar jurisprudence on ouster clauses from other Commonwealth countries that had been inspired by the landmark decision of the House of Lords in the animistic case versus Foreign Compensation Commissions and ANA. This court developed the interpretive model to be followed, in that case, the vetting board. I have considered the dictum in that case and the imposed obligation by this court under Section 3C of the Supreme Court Act, which provides that we must develop rich jurisprudence that respects Kenya's history and traditions and facilitates its socio-economic and political growth. Accordingly, before declaring the applicability or otherwise of the basic structure doctrine in Kenya's constitutional context, a court is obligated to take into account our constitutional history, especially bearing in mind that the doctrine, which found roots in 1973 in India, was available when the framers of the Constitution of Kenya conceptualized the provisions of Chapter 16 on amendments. Another way of looking at the matter is to ask a pertinent question as to whether there are gaps identified in particular in regard to the provisions of Chapter 16 of the Constitution requiring to be sealed by the basic structure doctrine. In addition, in evaluating whether the basic structure doctrine is applicable in our constitutional system, a court must take into account the purposive and value-based interpretation decreed by Articles 10, 20, 4, 159, and 259 of the Constitution. Such an approach to constitutional interpretation begins from and remains rooted in the text of the Constitution, whilst interpreting it holistically, giving effect to its values and principles, and never losing sight of the historical context and the backdrop of the provisions being interpreted. Therefore, to comprehend and contextualize whether the Constitution contemplates the basic structure doctrine, the starting point should be the rationale provisions of Chapter 16 as documented in the preparatory documents from the constitution-making process. It is an understatement to say that Kenyan independent constitution endured a legacy of hyper amendments during the post-independent period. The former constitution was flexible, giving the legislature wide power and discretion in amending it. As a result, Parliament undertook so many amendments to the Constitution that it lost its original character. The most significant amendments being the merger of the Senate and the House of Representatives to establish a unicameral legislature, abolition of the quasi-federal regional governments that led to the establishment of a unitary state, and alteration of the entrenched majorities required for constitutional amendment, making it easier to amend the Constitution. Yet another repulsive amendment was the abolition of the security of tenure for judges and other constitutional office holders. Ultimately, the amendment that finally broke the proverbial camel's back, giving rise to the clamor for a new constitutional order, was the one that converted the country from a multi-party democracy to a de jure one-party state in 1982. Informed by this history, Kenyans yearned for a stable constitutional system where the power to amend the constitution would not be abused for short-term interests by political elite. The CKRC report records at page 74 that Kenyans expressed what they wanted, and I quote, "There is a need to protect the constitution against indiscriminate amendments." What emerges from the historical account is that there was a strong concern that the country should adopt provisions on amendment power that are able to protect the constitutional order from abusive amendments. But this was not all. There was also a recognition that the constitution must remain flexible in order to adjust to political, social, economic, technological, and other changes that to take place in the polity. In effect, the overarching imperative that informed the drafting of Chapter 16 was the need to find a proper balance between rigidity and flexibility. The quest for a balance between rigidity and flexibility is evident in the tiered amendment provisions in Chapter 16, which stipulates 3 pathways for amending the Constitution. The first pathway, under Article 256, provides for amendment by parliamentary initiative. This process involves public participation and approval by the Houses of Parliament through a vote of endorsement by 2/3 of all members of each House during the second and third reading of the amendment bill. The second pathway, under Article 257, provides for amendment by popular initiative. This process involves collection of at least 1 million signatures from registered voters in support of the popular initiative by the promoters of the initiative. Approval of the initiative by the majority of the county assemblies, and passage of the bill by the majority of the members of each House of Parliament. In this second process, if either House of Parliament fails to pass the bill, the proposed amendment is submitted to the people in a referendum. The third pathway, under Article 255, relates to what has come to be known as the entrenched provisions of the Constitution. Some of the Court of Appeal judges referred to these entrenched provisions as forming the basic structure of the Constitution. Article 255(1) of the Constitution stipulates that in addition to adopting either the parliamentary initiative or popular initiative pathway, where an amendment relates to the following articles, a bill to amend those provisions shall be subjected to a referendum. These are the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the national values and principles of governance in Article 10, the Bill of Rights, the term of office of the President, the independence of the judiciary and commissions, and independent offices, to which Chapter 15 applies, the functions of Parliament, objects, principles, and structure of devolved government, or the provisions of Chapter 16 on amendment of the Constitution. Approval through the envisaged referendum under Article 255(2) must satisfy 2 conditions. At least 25% of the registered voters in each of at least a half of the counties should vote in the referendum, and such an amendment should be supported by a simple majority of the citizens. A reading of the 3 pathways for amending the Constitution in Chapter 16 clearly shows that Kenyans were alive to the historical legacy of the culture of IPA amendment in the pre-2010 era and sought to tame any abuse of the amendment power. In particular, Article 255(1) and 2 of the Constitution demonstrates that, alive to the of IPA amendments, the Kenyan people sought to ring-fence the core fundamental commitments of the Constitution by entrenching them and subjecting the process of amendment to deepened public participation, as well as imposing a downstream constrained veto by stipulating that the entrenched provisions enumerated in Article 255(1) of the Constitution can only be amended through a referendum process. The rationale of entrenching the provisions mentioned in Article 255(1) of the Constitution is, in my view, informed by the very democratic idea that constitutional amendments of a fundamental nature should take place through a deeply participatory process and be ratified by the people, being the ultimate sovereign of the polity, through a referendum. The approach in balancing flexibility and rigidity in constitutional amendment adopted in Chapter 16 reflects and compares favorably with modern constitutional architecture and design. Drafters of contemporary constitutions pursue the goal of balancing rigidity and flexibility through what has been termed as tiered design amendment rules. This argument is augmented by the articles cited before us by Professor Rosalind Dixon and David Randau in their writing titled Tiered Constitutional Design. Under the tiered constitutional model, amendment rules vary with provisions that are core to fundamental to constitutional systems being placed on a higher tier and made more difficult to amend. The amendment rules under the Constitution adopt this modern tiered constitutional design, combining the virtues of rigidity and flexibility by having different amendment procedures apply to different parts of the Constitution. The core foundational values, principles, and structures of the Constitution have been granted a higher level of entrenchment to ensure the stability of the constitutional system. It follows, therefore, that Kenyans were conscious of the core constitutional values, principles, and structures that they wanted protected from abusive amendments, and they protected them through entrenched provisions in Article 255 of the Constitution. In my view, therefore, the framers of the Constitution, well aware of the basic structure doctrine, chose to ring-fence some key features from flexible amendments. And if it was their intention to provide for eternity clauses or the basic structure doctrine, nothing would have stopped them from doing so. The next question that follows is whether it was necessary for the two superior courts to adopt the basic structure doctrine and thereby devise a fourth-way path for amending the Constitution outside the three pathways that are stipulated in Chapter 16. To answer this question requires one to appreciate how the High Court and the majority of the Court of Appeal judges proceeded to analyze Chapter 16. It was on the premise that, based on the history of IPA amendments of the reviewed Constitution during the pre-2010 dispensation, the Constitution demanded heightened procedures beyond the tiered design of the amendment procedures provided in Chapter 16 that would make the Constitution more difficult to amend. The two courts, therefore, did not go into a detailed analysis and to specifically point out the actual shortcomings of the provisions of Chapter 16, especially in light of all the 21 unsuccessful attempts that have been made over time, over the last 10 years, to amend the Constitution. The Court of Appeal, in my respectful view, and a duty to analyze the findings of the High Court and specifically point out whether there were apparent inadequacies as far as the provisions of Chapter 16 were concerned. Looking at the history, as stated above, as well as the provisions of Chapter 16, it is clear to me that Kenyans sought to achieve a balance between rigidity and flexibility in the amendment process. Kenyans did not want to shift from one extreme of hyper amendment to another extreme where no amendment can take place. That is, from hyper amendment to ultra rigidity in the amendment process. Rather, what Kenyans desired is a balance between rigidity and flexibility, as reflected in the tiered amendment process in Chapter 16 of the Constitution, with the core or essential features of the Constitution being accorded heightened protection, but still open to amendment through an enhanced, inclusive, and participatory process that culminates in our people exercising their sovereign power through ratification in a democratic process in the form of a referendum. The High Court and the majority of the Court of Appeal, with tremendous respect, failed to appreciate that the tiered amendment process is one of the options available in the menu of constitutional designs options for dealing with the practice of abusive amendments, just like other design options limit amendability. For example, eternity clauses and basic structure doctrine. Therefore, where Kenyans have selected the tiered amendment procedure as their response to the culture of hyper-amendability, I find it difficult to justify this judicially created fourth pathway of amending the Constitution founded on basic structure doctrine. Unfortunately, there was no justification provided to demonstrate the lacuna in the Constitution, and hence the need to call in hand the basic structure doctrine to enhance the existing tools of interpretation. The 2010 history of Kenya is replete with precedents of application of foreign laws and doctrines from Commonwealth and other jurisdictions, which was done due to absence of local statutes. Today, I dare say that courtesy of our Constitution, we have sufficient arsenals that include our own canons of interpretation, which we must exhaust before borrowing from other jurisdictions. Further, I see a potential conflict within the constitutional system with the judiciary created fourth pathway for amending the Constitution. This is for the simple reason that in our constitutional dispensation that is people-centered, our nascent democracy that respects the doctrine of separation of powers by vesting the legislative power in the legislature, to create a fourth pathway within a scheme of amendments would bring into question the place of the participation of the people and the place of the legislature in that scheme. Taking into account where we are at in our constitutional democracy, Kenyans needed to be consulted on whether it is their wish to introduce the fourth pathway for amending the Constitution. In other words, we judges should be vigilant lest we are accused of usurping the sovereign power vested in the people by introducing a constitutional amendment through judicial fiat. Put differently, the tiered amendment process provided in Chapter 16 of the Constitution is a design option for dealing with the problem of abusive amendments and obviates the need for judicially created limits to amendments power like the basic structure doctrine. This is in line with the view expressed by Professor Rosaline Dixon and David Randau. My take home from this scholarly perspective is that tiered design of constitutional amendment process is one of the design options used to curbing the problem of hyper amendments. Professor Rosanai rightly points out in his well-balanced amicus brief that the applicability of the basic structure doctrine depends very much on the context. The most important contextual consideration is the balance between flexibility and rigidity of the amendment process. The more difficult the amendment process, the less there is need for a doctrine of implied limits to amendment power. The jurisprudential underpinning of this view is that in a case where the amendment process is multi-stage, involves multiple institutions, is time-consuming, engenders inclusivity and participation by the people in deliberations over the merits of the proposed amendments, and as down of the basic structure doctrine into a constitutional system before exhausting homegrown mechanisms. Moreover, I fully agree with a portion of the judgment by Sishare J, where she questioned the viability of relying on judges to interpret on case-by-case basis on whether a particular provision of the Constitution is amendable. To put this into perspective with respect to our constitutional architecture, amendment of entrenched provisions of the Constitution relating to the matters listed in Article 255(1) through popular initiative route requires, first, there must be public participation throughout the amendment process by dint of Article 10(2) of the Constitution. Second, collection of 1 million signatures from registered voters in support of the initiatives as provided in Article 257. Third, support of the initiative through approval of the bill by a majority of the county assemblies as stipulated in Article 257(7). Fourth, consideration of the bill by the bicameral House of Parliament, Article 257(10). Fifth, subjection of the bill to a referendum in terms of Article 255, in which at least 25% of the registered voters in each of at least half of the counties vote in the referendum, and the amendment is supported by a simple majority of the citizens voting in the referendum. 6, it should also be appreciated that the processing of the bill in county assemblies and the bicameral Houses of Parliament is also subject to a further public participation requirement in terms of Article 196 and 118 respectively. 7, Article 88(4)(g) imposes an obligation on voter education on IEBC. Amendment of the entrenched provisions under parliamentary initiative routes by dint of Article 10(2) of the Constitution requires public participation, which must inform the entire amendment process. Second, the amendment bill has to go through the bicameral House. Looking at the two pathways for amending the entrenched provisions, it is inescapable to conclude that amending the core of fundamental provisions of the Constitution is a multi-staged, multi-institutional, time-consuming process that ensures that a constitutional amendment process that touches on the core of the fundamental aspects of the Constitution is transparent, inclusive, engenders the participation of the people, amendment process under the Constitution, meets the set criteria as to when judiciary created basic structure doctrine is inappropriate and undesirable. Therefore, the two courts below and by finding a fourth judiciary created pathway for amending the Constitution, which is with respect tantamount to amending the Constitution through the judgment of the court. To buttress the point of tiered amendments, post-2010 Constitution, adequate work against abusive amendments. As pointed out by Sishare J in a dissenting opinion at the Court of Appeal, there have been 21 failed attempts to amend the 2010 Constitution during the first decade of its operation. 19 of these were through the parliamentary initiative and 2 were through the popular route. It is also notable that although the amendment bill had gone the farthest in amendment process, it was yet to be subjected to the ultimate downstream veto of the referendum process. Comparatively, the U.S. Constitution had undergone 12 major amendments by its 10th birthday. In essence, it is right to conclude that the resilience of the 2010 Constitution in its first decade is proof that Kenyans attained the goal of balancing flexibility with rigidity in designing the amendment power as reflected in Chapter 16 of the Constitution. It ought also to be appreciated that judicial protection of implied limitation to the amendment power, such as through the basic structure doctrine, become increasingly required in context where the country has two flexible constitutions that can be amended fairly easily. Therefore, while it was inappropriate in the pre-2010 dispensation for the High Court, Lingera J, as it then was in the Joya case, to recognize the basic structure doctrine under the repealed Constitution, there is no such need under the 2010 Constitution. This view is founded on the premise that the risk of abusive amendments has been tamed by the tiered amendment process that entrenches the core of essential provisions through a heightened, elaborate amendment process. Considering the progressive nature of the Constitution, a three-judge bench, Koriu, Goge, and Odunga in Priscilla Ndururu case, expressed skepticism as to the continued relevance of owning the Joya case on the basic structure post-2010 Constitution in light of the provisions of Article 255 of the Constitution. In contrast, the unique context of India with a too flexible constitution that grants the legislature wide discretion in amending the Constitution arguably justifies the judge-made basic structure as developed and practiced in India in order to stabilize the constitutional order and prevent the practice of abusive constitutional amendments, given the low threshold for amendments in the text of the Constitution, just as it was in our case prior to the 2010 Constitution. Although I think I've said enough to demonstrate why I disagree with the judgments of the majority of the Court of Appeal bench regarding the application of the basic structure post-2010 constitutional order, I will briefly highlight some of the critical aspects which were not considered by the two superior courts, and if the judges had done so, perhaps they would have come to a different opinion. Number one, the superior courts failed to appreciate that the concern with the culture of hyper amendment had already been taken into account during the drafting of the Constitution of Kenya 2010. This led to the design of the tiered amendment process that balances flexibility and rigidity. In such a context, the correct judicial posture ought to have been fidelity to our Constitution. This is informed by the reality that the Constitution, to a large extent, is self-contained and self-regulating in dealing with the legacy of abusive amendments in the former constitutional amendments. Therefore, there is no justification for courts to go outside the four corners of the Constitution to create a fourth pathway for the amendment of the Constitution. Number two, the Court of Appeal failed to analyze the provisions of Chapter 16 and to arrive to its own independent conclusion on the shortcomings of the three-tiered process, and to state clearly whether it was necessary to call in aid a foreign doctrine, also to take into account the amendment practice in the post-2010 dispensation in the analysis of the Kenya's constitutional history, which shows that Chapter 16 of the Constitution has brought stability in the constitutional system, in contrast to the culture of hyper amendment under the former constitution. There have been multiple attempts to amend the constitution, which were all unsuccessful, meaning that the amendment process is not flexible, as in the Indian case. 3, the Court of Appeal failed to take into account the fact that Chapter 16 is one of the entrenched parts of the Constitution under Article 255(1) of the Constitution. Therefore, it could not be amended by the courts through creating a fourth pathway of amending the Constitution without following the constitutionally ordained amendment process provided for under Article 255(1) of the Constitution. And fourth, the Court of Appeal failed to appreciate that Kenyans were aware of the idea around the basic structure doctrine during the Constitution making phase in light of the legacy of the case of Joya, and yet did not embrace the idea of a veto to the amendment power as represented in the basic structure doctrine, as well as related to doctrines like eternity clauses. The CKERC report on page 76 indicates that Kenyans yearned for power to have a say in amending the core fundamental features of the Constitution through a referendum and an inclusive and participatory process. This was done through the provisions of Article 255 of the Constitution. Another aspect of the majority judgment of the court that I need to address relates to how the two courts treated the historical background informing the drafting of Chapter 16. It is evident that the decision on the question of the application of the basic structure and doctrine within Kenya's constitutional system was largely turned on historical inquiry, clarify, and provide interpretive guideline on the intent of the Kenyan people during the drafting of the Chapter 16. While this court, as in the past, celebrated the virtues and utility of the historical context, the background to the adoption of the Constitution in the Constitution interpretation is imperative. Given the subjective nature of the historical narrative, public that there was cessation of hostilities between the two political sides in what they called a handshake through a joint communique, building bridges to a new Kenya. It is in the quest to implement this noble objective of promoting national unity and overcoming other challenges identified in the joint communique that the President appointed the Building Bridges Task Force. On 26 November 2019, the BBI Task Force released their report, which was unveiled to the public. On 10 January 2020, the President appointed the BBI Steering Committee with the terms of reference that were stated therein. As far as the President's actions with respect to setting up the BBI Task Force and BBI Steering Committee to further the agenda of promoting national unity were concerned, in my view, these actions cannot be faulted. Indeed, they are roundable acts of statesmanship executed within the ambit of the provisions of Article 131(2)(c) of the Constitution. This article demands nothing less from the President, as it directs the holder of that venerable office to promote and enhance the unity of the nation. However, it is important to clarify that the legal constitutional question before this court does not go to the propriety of the pursuit of the Building Bridges to Unity project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the President can be pursued through a popular initiative route prescribed in Article 257 of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by introduction of the popular initiative as a route for amending the Constitution. This is pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The Constitution making history that I have highlighted demonstrates that a popular initiative was a tool carved out exclusively as a route for constitutional amendment by citizens. In essence, amending the Constitution through a popular initiative was intended to be a citizen-driven and a citizen-centered process. The citizen-centric nature of a popular initiative is linked to the fact that it is conceived as a means for direct sovereign power to be expressed as contradistinguished with the parliamentary initiative, which lies to the realm of the derived or delegated sovereign power. Under this understanding, the popular initiative is supposed to be triggered from below at the initiative of the citizenry, as opposed to representative institutions. In other words, the popular initiative is intended to give citizens acting outside the institutions of the state a means to activate or trigger the exercise of their sovereign power. This understanding of the centrality of the citizens in activating a constitutional amendment process through a popular initiative is projected in the book that was referred to us by Joe Cornlois, titled Constitutional Power and the Law. My analysis of Article 257, the history of constitution-making process, and the authority cited in the said book, although persuasive, indicates that a popular initiative is an exercise of direct sovereign power that excludes the representative institutions, that is, the legislature and the presidency, which only exercises power that is derived or delegated sovereign power as distinguished in Article 1, 2, and 3 of the Constitution. In other words, it is a means of direct democracy and indeed direct democracy can only be exercised by the people, not their representatives, since that would convolute the form of democracy at play. It follows, therefore, that a popular initiative in a constitutional amendment process ought to be seen as an avenue through which citizens engage in the exercise of their sovereignty. As such, state organs, being non-bearers of direct sovereignty, have no right to activate the popular initiative. This leads to the conclusion that the popular initiative is a preserve of the citizens, the one popularly known in Kenya as the Wanjiku. It ought to be appreciated that the Constitution provides normative markers for how, when, where, and by whom particular powers are to be exercised. Article 257 delineates who has the power to undertake what duty or obligation as a right to undertake specific measures with respect to the constitutional amendment process. It is in appreciation of this that I need to interrogate the argument that the institution of the presidency has the authority to initiate a popular initiative in light of the overarching motive of the Constitution.
Invested in him is commanding her left hand to grow.
This approach of explicit and limited power can be understood in light of the legacy of domination of the constitutional system by imperial presidents in pre-2010 dispensation. As a result, Chapter 9 of the Constitution lays out in great detail the powers and the authority of the President and how such power is to be exercised. Another reason that supports the finding that the President was not envisaged as an initiator of a popular initiative is the role of the President with respect to entrenched matters listed in Article 255, 1 of the Constitution, Article 256.5 as read with Article 257.10 of the Constitution, which grants the President a law that can be typified as serving as the guardian of the amendment process. In that, where a constitutional amendment bill is presented for assent, the President has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship role over the amendment process ought not to be undertaken by the prayer in the amendment process. I therefore endorse the finding by the two superior courts that the President ought not to be both a prayer and an umpire in the amendment process. The last reason for finding that state institutions and presidents are excluded from using the popular initiative is to be found in Article 255, 3b of the Constitution. It shows that the Constitution recognizes a distinction between the people, the state bodies like Parliament. It therefore follows that a state body like the institution of the presidency cannot fall within the rubric of the people, as the very text of the Constitution makes this distinction. This leads me to the inescapable conclusion that state institutions and state organs, such as the presidency, cannot initiate constitutional amendments via the popular initiative route provided for under Article 257 of the Constitution. Nonetheless, this finding does not dispose the issue, as counsel for the President and even the Attorney General sustained an argument that barring the President from initiating or pursuing constitutional amendment process through a popular initiative was a violation of the President's political rights as protected for in Article 38(1) of the Constitution. Given that a process to amend the Constitution is a democratic process which is meant to give effect to self-government, the limitation and promotion of an initiative to change the Constitution is a political choice protected under Article 38(1)(c) of the Constitution. However, there is an additional handle in deciding whether a right is applicable in a given factual situation. This is the concern with the rights range of application as provided in Article 22 of the Constitution, which provides every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature and the right of the fundamental freedom. What I deduce from this provision is that a court is an obligation to interrogate whether a person arranging a violation of a right is actually a beneficiary of that right in question. In this context, it is notable that Article 38(1) grants the freedom to make the political choices to every citizen. The citizen qualifier speaks to the range of application of the freedom to make political choices by limiting the rights enjoyments to the citizens. Therefore, for one to be a beneficiary of the freedom to make a political choice, they must fall within the category of the citizen. Based on the citizenship qualification, the freedom to make political choices is a right that does not accrue to state organs or institutions. State organs or institutions cannot be citizens because under Chapter 3 of the Constitution, citizenship is limited to living human beings, excluding state organs. Consequently, while the President, when acting in his private capacity as a citizen, can enjoy freedom to make political choices, this right does not accrue to the institution of the Presidency, which is a state organ. The Presidency and other state organs do not fall under the rubric of citizens. I therefore find that exclusion of the institution of Presidency and other state institutions from initiation of a process to amend the Constitution through the popular initiative route does not violate the political rights protected under Article 38(1) of the Constitution. The last aspect of this issue relates to whether it was established through evidence that the process to amend the Constitution through amendment bill was initiated by President. At the outset, it should be pointed out that the concurrent findings by the two courts below was that the President, by a number of antecedent acts, and initiated the process, and the state was the real force behind the amendment process, including through the use of state resources to support the process. In a challenge to this finding, it was argued by the Attorney General and the BBI National Secretariat that it is the BBI National Secretariat through Honorable Dennis Wawero and Honorable Junet Mohammed who are the initiators and promoters of the impugned constitutional amendment initiative and not the President. An examination of the evidence before the courts revealed a number of things relevant to this factual determination. For starters, the President and the National Executive took certain actions which portray its role in the initiation and promotion of the constitutional amendment. The President did not do those things as a private citizen, and this is clearly demonstrated in a number of ways. One, the President signed off the communique in March 2018. The official title of the President. The communique was published in a paper bearing the coat of arms of the Republic and the seal of the President. The President appointed the BBI task force and the BBI steering committee through Gazette notice of 5154 and 264 of 2018, respectively. The President received the official reports through a state function as President. As a result, it cannot be disputed that the President was involved in the initiation of the amendment bill. However, in my considered view, the President cannot be blamed for this because it is the promoters who took over the amendment bill under the auspices of the BBI National Secretariat, who had, by invoking the popular initiative route under Article 257, to pursue the amendment process. It is my finding that the genesis of the amendment bill can be traced to all these actions. I therefore affirm the factual findings by the two superior courts that the President was involved in the amendment bill, and agree with the finding by Tuyot J. I believe I have stated enough to support by conclusion that the President of the state institutions are not permitted to initiate or promote a constitutional amendment process through the popular initiative route envisaged in Article 257 of the Constitution. This now takes me to the third issue, whether the second schedule to the amendment bill was constitutional. To put this question in context, it ought to be appreciated that the second schedule was intended to serve as a transitional scheme of implementing Clause 10 of the amendment bill. Clause 10, which intended to amend Article 89 of the Constitution, provided, and I quote, Article 89(1) of the Constitution is amended by deleting the words 290 and substitute therefore with words 360. Clause 1(2) of the second schedule proceeded to distribute the additional 70 constituencies as per the schedule. It is in the above context that the constitutionality of the second schedule, directly allocating and apportioning the proposed constituencies to specified counties, were challenged. The two superior courts were unanimous in their findings that the second schedule to the amendment bill was unconstitutional. This finding was based on the substantive grounds that the second schedule violated the basic structure of the Constitution by purporting to take away the mandate of the IEBC, an independent body under the Constitution. Further, it was contended that the second schedule impermissibly directed IEBC on the execution of its constitutional functions. It is imperative to begin the analysis on the constitutionality of the second schedule of the amendment bill by pointing out that given my earlier finding that the basic structure doctrine does not apply under the Constitution of Kenya 2010, my determination of this question rests on the procedural concerns linked to whether there was public participation in coming up with the second schedule. This is because the provisions of Article 89 are amendable as long as due process is followed. It ought to be appreciated that amendments touching matters falling within the remit of Article 255(1), which are the core fundamental commitments of the Constitution, ought to be undertaken through a highly participatory and inclusive process. It should be noted that directly allocating and apportioning constituencies usurps the mandate of IEBC, an independent constitutional commission, removing the possibility of judicial review of the delimitation as an effect on the independence of the judiciary. The centrality of the constituencies as units of political representation in the National Assembly means that they ought to be apportioned and allocated by a neutral and professional actor, much more so because malapportioned constituencies have the potential of diluting the power of the votes, hence threatening the animating goal of fair and effective representation, which is at the heart of the foundational value of democratic governance enshrined in Article 4(2) and 10(2)(a) of the Constitution. Further, since the constituencies are units of social and economic development through allocation of national government constituency development fund and the recruitment into disciplined forces such as the Kenyan Defence Forces and the National Police Service, the delimitation of constituencies has implications on the constitutional values and principles of equity and social social justice enshrined in Article 10(2)(b) of the Constitution. It goes therefore without saying that the delimitation of constituencies must be accompanied by a process that is fair and just, which is the golden thread that runs through our constitutional order as elaborated in the preceding chapters. I've also considered that this process was not subjected to public participation and referred to cases by this court, the British American Tobacco case, that provided that the tests for adequate public participation should be reasonableness. That should be the threshold. Following from this case, I now examine whether there was reasonable notice and opportunity afforded to the public for generating the views and deliberating on apportioning and allocating the disputed 70 constituencies as provided for in the schedule. An examination of process leading to the BBI task force and the BBI steering committee reflects that there was reasonable participation and involvement of the people in coming up with the recommendations of the bill that was published on 21st October 2020. There is, however, no evidence of any form of public participation or deliberation between 21st October 2020 and 25th November 2020 when changes to the draft constitution of Kenyan bill was made, including the addition of the second schedule. This leads, therefore, to my conclusion that the constitutional threshold of reasonable public participation was not met when the second schedule of the amendment bill was presented. Consequently, I come to the conclusion that the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Article 10(2) of the Constitution. I move now to the fourth issue on the presidential immunity. At the outset, it is important to point out that given the Court of Appeal held that the President was not served with the petition number E400 of 2020, in the proceedings before the High Court in which this question arose, it was improper for the Court of Appeal to proceed and adjudicate the question of interpretation of Article 143(2) of the Constitution. However, as considered in the President's written submissions filed before the High Court, there is a public element in this matter, so this Court should clarify and settle the law on the nature and scope of protection of the President from civil legal proceedings, considering the findings of the two courts below. It is generally recognized that immunity from legal proceedings usually takes two forms. First, immunity from liability protects officials not from proceedings being undertaken, but from personal liability at the end of the proceedings, which relates to enforcement. Second, immunity from proceedings is a broader form of immunity that overthrows the court's or tribunal's jurisdiction to hear a matter because the parties against whom the proceedings are undertaken enjoys immunity. Further, there is absolute and qualified immunity. Absolute immunity has no limitation as to its application, while qualified immunity usually has limitation, like extent of actions and other related to other official function, whether done lawfully or done in good faith. The Constitution contemplates immunity of certain officials in the performance of their functions. For example, Article 160, a member of the judiciary; Article 250, a member of the commission; Article 143, criminal proceedings shall not be instituted against the President or a person performing the functions of that office during the tenure. From the structural reading of the above provisions, there are glaring distinctions that illuminate the nature and scope of presidential immunity envisaged under Article 143(2) of the Constitution. Firstly, all the officials set out above enjoy immunity as persons, holder of office or member of a commission, but not their offices. Whereas the President enjoys immunity as both the person in the office and the office itself. This is evident from the choice of phraseology used in Article 143 to the effect that the President or the person performing the functions. To make the point clearer, one can contrast the nature of immunity envisaged in Article 143 to Article 259 for an holder of an independent office. Consequently, this brings me to the inescapable conclusion that the immunity of the President is unlike that of the other state actors. The President not only enjoys functional immunity like all public officials who perform state duties, which protects them from civil liability for official functions, they further enjoy sovereign immunity as the end of state and the single representation of the sovereignty of the Republic. Indeed, it is only sovereign immunity that can immunize anyone against both proceedings and criminal liability, because any other immunity would be related to official functions and therefore would inherently be a qualified immunity. The two courts below, especially majority opinion of the Court of Appeal, relied on the phrase "in the exercise of their powers under this Constitution." I am conscious that part of the President's role in the performance of their functions is the interpretation of the Constitution as to whether or not it gives them power to perform particular roles. Upon such interpretation, the President either acts or fails to act in the belief that either that power exists or does not exist. It would follow then that if proceedings were to be instituted against the President after the interpretation which is considered to have been wrong interpretation, then such proceedings would fall within the immunity contemplated in Article 143(2), in that it would be within the performance of the President's functions. There is no provision allowing or requiring the President to seek an advisory opinion from the judiciary before exercising their duties or before determining whether they have power to perform any official act. And in any event, this would generally bar the separation of power. Further, the two superior courts held that the President or the person performing the functions of the President is not above the law and should be amenable to the law if they act against the Constitution. The implication of this finding is far-reaching and therefore calls for a very careful analysis and consideration by this court. It is necessary to state that the Constitution has provided for how the President and the Executive in general can be kept in check through political accountability, with the provision that the President is liable for impeachment under Article 145 of the Constitution. The grounds for impeachment listed under Article 145(1) of the Constitution includes gross violation of the Constitution or any other law, commission of a crime under national or international law, or gross misconduct. This means that there is a clear avenue to check the President's conduct as acknowledged by this court, by the Court of Appeal in the case of Minister for Internal Security and Provincial Administration versus Center for Rights, Education and Awareness. With respect to legal accountability, the protection of the President from legal proceedings under Article 143 does not mean that President's actions or omissions cannot be challenged in court. Anybody or a party aggrieved by the President's actions or failure can initiate proceedings against the Attorney General, who by virtue of being the legal representative of the government in legal proceedings also represents the President. As such, pursuant to Article 156(4) of the Constitution, The exercise of public power by the President can be challenged in court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein a court may issue appropriate remedies. In effect, findings of the two superior courts and the ramification of rendering Article 143(2) of the Constitution ineffective or superfluous. This is an interpretive path that, in my view, is not open to the courts. An interpretation of the Constitution that resorts to an amendment via a judgment is tantamount to judicial overreach. This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or a person performing the functions of the President during the tenure of the office. I hold that civil proceedings cannot be instituted against the President or a person performing the functions of the President of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Such proceedings can be instituted against the President via the Attorney General. Issue number 5 on public participation, whether there was public participation. The issue was framed by the court with two components. The first relates to the role of IEBC and Article 257(4), whether IEBC is under an obligation to ascertain that promoters of a popular initiative have undertaken public participation during the collection of signatures. It is clear to me that there is no direct requirement arising from the provision of Article 257(4) that imposes an obligation on IEBC to ascertain that the promoters of the popular initiative have undertaken public participation. Nonetheless, the High Court held that IEBC was obligated to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation as provided for under Article 10(1) of the Constitution. It is necessary to keep in mind, to keep reminding ourselves that IEBC, being a creature of the Constitution and statute, can only discharge a mandate vested in it explicitly by the law. This is a direction given under Article 10, which identifies the rule of law as the national value and the principle of governance. It follows that IEBC, like all other public bodies, cannot craft or innovation or interpretation extend its power to include ascertaining whether a promoter or a popular initiator has complied with the public participation requirements under the Constitution. Equally, courts should not encourage extension of powers by constitutional or statutory bodies. Such bodies must operate strictly within the four corners of their constitutional and statutory mandates. Given this view, unless there is a statutory framework enacted that confers power on IEBC to ascertain whether a promoter has undertaken public participation, the exercise of such a mandate would be a mere overreach. In the upshot, therefore, it is my finding on the first part of the question as framed that there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining that the amendment bill had met the constitutional requirements for transmittal to the county assemblies. As regards the second part of the question as framed, relates to whether there was public participation in respect to the amendment bill. In determining this question, it ought to be appreciated that while participation of the people has been identified as foundational value and principle of governance under Article 10(2), it is even more crucial with regard to processes that would lead to constitutional amendments. This is so because it is the people's acceptance and ownership that grants democratic legitimacy and authority to the Constitution. It is against the standards that are set in the case of BAT by this court that I proceeded to examine whether there was public participation as regards the Constitutional Amendment Bill 2020. From the provisions of Article 257, it is discernible that there are 4 stages in the amendment process under the popular initiative route. The initiation stage, that is the correction of signatures, which typically involves the promoters of the initiative setting the referendum agenda. However, this is to be within the context of the constitutionally guaranteed opportunities for citizens to influence the process. It is also not lost to me that an onerous requirement that a promoter conducts public participation before presenting signatures for verification at this stage would be unreasonable, because the whole process may be rejected by IEBC like it did the 2 popular initiatives dubbed Okoa Kenya and Funguza Mizigo. Moreover, unlike subsequent stages where the cost of public participation is borne by the public bodies, that is the county assemblies, the IEBC, the cost of public participation will be borne by citizens or a group of citizens. In such a context, I am of the view that the requirement of public participation during the period proceeding and during the collection of signature under the popular initiative process should not impose onerous requirements on a promoter of the initiative. The second stage, which is the assembly stage, seems to lend itself more to public participation. This is because the Constitution imposes a normative obligation for the public participation in legislative affairs. Moreover, a timeline of 3 months within which county assemblies ought to consider the bill of the constitutional amendment supports a reading that assemblies must solicit for input from the public. The third stage, that is passage through the Houses of Parliament, is another key stage for public participation. The fourth, the referendum stage, is intended to serve as a national deliberative moment. Hence, duty bearers, including IEBC, have an obligation to facilitate a broad participatory process that includes voter education. It is important to reiterate that the requisite mode, degree, scope, and extent of public participation or sufficiency thereof is to be determined based on the peculiar circumstances of each case. Nonetheless, public participation must not be an illusion, but a meaningful engagement. On the question of whether there was reasonable public participation and the question of burden of proof, Okwengu and Kiagi JJA held the view, and rightly so, that by dint of Section 112 of the Evidence Act, once there is an allegation of lack of public participation, the burden shifts to the person charged with the responsibility of performing the same to establish adequate participation. However, Tuyot JA arrived at a slightly different conclusion. In his view, the burden could only shift to the promoters of the amendment bill if there was evidence to the effect that the persons were aware of the amendment bill. The evidence before the court shows there was a reasonable attempt at public participation with respect to the impugned initiative. This view is supported by the evidence of Donis Wawero, co-chairperson of the BBI National Secretariat. In his affidavit sworn on 5th February 2022, which was in response to petition number 416 of 2020 by Morara Omoke. He deposed that BBI Task Force Steering Committee was and the amendment bill were products of comprehensive consultative public engagement all over the Republic, which process entailed voluntary nationwide public participation. In addition, he annexed with affidavit invitations, deliberations, reports, and memoranda to that effect. I have also taken time to go through the BBI Steering Committee report, and there is evidence of public participation with regard to the process as documented on page 2 of the report, which I have reproduced in my judgment. There was no challenge to the contents of the BBI Steering Committee report and the deposition by Dennis Waweru, which therefore leads to an unavoidable conclusion that there was reasonable public participation with respect to the amendment bill, save for the second schedule thereto. As far as the second schedule of the amendment bill is concerned, as I have discussed earlier, it was a late addition to the process. It is worth reiterating that the evidence of public participation runs up to the launch of the Steering Committee report that took place on 21st October 2020, wherein the draft amendment bill was attached and unveiled to the public. This version did not have the second schedule in question. There is no evidence of public participation between 21st October 2020 and 25th of November 2020, when the amendment bill was published and introduced in the second schedule for the first time. Having made the above findings, I need to point out in obiter that there is need for Parliament to enact a legislative framework to guide and regulate the process of public participation. While the Constitution sets a broad normative obligation for public participation in various governance processes, there is no legislative framework regulating how this obligation ought to be implemented. It is instructive to note that there have been 3 bills tabled in the Houses of Parliament with respect to providing a legal framework, but none of them have been successful. It ought to be appreciated that legislature has a duty to fulfill its obligation under the Constitution by enacting laws to actualize constitutional imperatives. In the end, I hold that there was reasonable public participation with respect to the amendment bill, save for the second schedule of the impugned bill. I now move to issue number 6, the composition and quorum of IEBC. The above issue was raised in the High Court, filed petition number 416 of 2020. It was arranged that IEBC lacked quorum for consideration and approval of policy matters relating to conduct of referenda, including verification of signatures under Article 257(4). As at the time the verification process was undertaken, only 3 commissioners of IEBC were in office, while 4 commissioners had resigned and they had not been replaced. The High Court was persuaded by the petitioners in the aforementioned case and held that the requisite quorum for purposes of carrying out its business, as well as the verification of the signatures, was lacking. The position was affirmed by a majority of the Court of Appeal bench, with the CR and JEA dissenting. In light of this background, that this court is called upon to determine whether IEBC was constitutionally infirm in terms of its composition. It ought to be appreciated that the legal regime on the composition of IEBC is regulated by the Constitution. While Article 88 of the Constitution establishes IEBC, provides for eligibility of appointment of its members and its mandates, this provision does not touch on its composition. It is Article 251 which provides for the composition of the commissions and independent offices. Article 248, 2C lists IEBC as one of the commissions and independent offices, making Article 251 the constitutional provision regulating its composition. The Article 251 provides as follows, I quote, "Each commission shall consist of at least 3, but not more than 9 members." Section 5.1 of the IEBC Act, which statute, according to its wrong title, is an act of parliament to make a provision for the appointment, effective operation of the IEBC, provided that the commission shall consist of a chairperson and 6 other members appointed in accordance with Article 254 of the Constitution. Section 5.1 appears to have influenced the reasons of the 2 courts below as regards the quorum. It is readily apparent that there is a possibility of the provisions of Article 250 of the Constitution and Section 5.1 of the IEBC Act being read as imposing different requirements with regard to the composition of IEBC. This leads to the question as to whether IEBC, composed of 3 commissioners, would be infirm to conduct its constitutional mandate, including the verification process provided for under Article 257. My finding on the above question is that Section 5.1 of the IEBC Act should be read in a manner that conforms to Article 251 of the Constitution. The reason being that Article 2, which expresses the supremacy of the Constitution, demands that no legal norm, including registration, should have an effect contrary to that expressed in the Constitution. In other words, the provisions of the Act of Parliament cannot erode the Constitution. The expressed intention of Parliament in registration cannot trump the normative command of the Constitution in a legal system where the Constitution is supreme. And this has been emphasized by the decision of this court in the case of Hassan Joho and also in the case of Mumo Matemo. I have also looked at persuasive jurisprudence from other courts in other jurisdictions which support this approach to statutory interpretation. Therefore, the implication is that IEBC is legally constituted when composed of the minimum number of 3 commissioners stipulated in Article 251 of the Constitution. As such, I find IEBC was constitutionally and legally composed when it undertook the verification of the verification process under Article 257 of the Constitution. This now takes me to the last issue. Issue number 7. On this issue, the High Court determined that Article 257(10) of the Constitution requires all specific proposed amendments to be submitted as separate and distinct referendum questions to the people in a referendum ballot paper, which are to be voted for separately and distinctively. This finding was affirmed by Nambuye, Okwengu, Kiagi, Gatembo, J.A. under a qualifier subject to the nature of the proposed amendments. Musinga J.A. disagreed with the learned judges of the High Court and held that what is to be subjected to the referendum is an amendment bill which the people are to approve or disapprove. On his part, Tuyot J.A. held that since IEBC had not received the requisites and had not discharged its responsibility of framing the questions, the matter was not ripe for determination. The first question for determination is a preliminary one, which is whether the question on formulation of referendum question was ripe for determination. The doctrine of ripeness focuses on when a dispute has matured. It prevents parties from approaching a court before a party has been subject subjected to any prejudice or real threat of prejudice as a result of a registration or conduct that is challenged. At the time of filing of the subject petitions, particularly petition E400 of 2020, the amendment bill was yet to be subjected to the county assemblies for debate. This means that IEBC was yet to be invited to make a determination on the manner and form of the referendum questions, taking into consideration that IEBC obligation under Article 257.10 of the Constitution had not arisen to yet JEA was right in finding that there was no live controversy before the High Court, which ought to have declined to make a determination on this case. Accordingly, I find that the issue of whether Article 277.10 of the Constitution entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. On the issue of costs, this being a public interest matter, I also find that each party, like it was found in the courts below, should bear their own costs. My findings, therefore, are number one, the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the 2 superior courts below are not applicable in Kenya under the Constitution of Kenya 2010. Number 2, the President is not permitted to initiate constitutional amendments or changes through a popular initiative route provided under Article 257 of the Constitution. That being the case, the Constitution bill does not pass muster as a popular initiative under the provisions of Article 257 of the Constitution. 3, the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Articles 10(2)(a) and 89(7)(a) of the Constitution. 4, civil proceedings cannot be instituted in any court against the President or the person performing the functions of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Issue number 5, there was no obligation on IEBC to ensure that the promoters of the impugned popular initiative complied with the requirements of public participation before determining the amendment bill. In addition, there was public participation with respect to the amendment bill, save with respect to the second schedule of the impugned bill. Issue number 6, IEBC and the requisite quorum to undertake the verification of signatures in support of the amendment bill and Article 257(4) of the Constitution. 7, I find the question raised regarding the interpretation of Article 257(10) of the Constitution on whether or not it entails or requires that all specific proposed amendments to the Constitution should be submitted as separate and distinct referendum questions was not ripe for determination. And lastly, on costs, this being a public interest matter, I find each party should bear their own costs of this litigation and also the other courts below. That is my judgment. I will now request the Honorable Justice Ouko to read his judgment.
Thank you, Judge President. This is a summarized version of my judgment. This appeal, consolidating 2 others, marks the first time in the history of the Supreme Court of Kenya to determine the remit of constitutional amendment through a popular initiative and Article 257 of the Constitution. The road traveled by Kenyans since 1991 in search of a new constitution, culminating in the 2010 document, has been sinuous and meandering. A road characterized by violent demonstrations, protests, mass actions, and even loss of life. Like the biblical narrow road which leadeth unto life, it was the way, the only way to a new beginning. And so at 10:26 a.m. on Friday, 27th August 2010, with a single stroke of his pen, President Mwai Kibaki endorsed the draft constitution, and there was a dawn of a new era. Before an ecstatic Kenyan people, and as cannons broke into a 21-gun salute, the president released 2 white doves as a sign of peace, love, hope, marking the birth of the Second Republic. Having emerged from this phase, Kenya embarked on building constitutionalism, giving meaning to the terms and values of the supreme law to which Kenyans must turn to for protection in times of need. It was time for the people to read meaning into its words. It's only through this robust enforcement, application, and interpretation by courageous citizens, lawyers, legislature, executive, and even more so by judges, that the Constitution will be safeguarded to realize the Kenyan dream contained in the preamble. And so, with the difficult history of constitutional making enumerated in the lead judgment of the Honorable Chief Justice, the question I pose: have the Kenyan people stayed true to the promise in the preamble that we, the people of Kenya, adopt, enact, and give this constitution to ourselves and to our future generations? So there were 7 issues that were framed, the first one being that on basic structure doctrine, and that's the one I now turn to. In the last 50 years, since the Supreme Court of India decided Casavananda case, the name Casavananda has been synonymous with the basic structure doctrine, and although the term basic structure has not been used, has been used in a few cases in this country in the past, it is during the hearing of this case from the High Court through to this court that it became a household name. I suppose, knowing Kenyans in our true unique sense, there may be children today who are called basic structure, perhaps basic structure George Ochola, just as there may be also in India children born in the 1970s who are given the name Casavananda after the Hindu spiritual leader who lent his name to the iconic case as the petitioner. Unfortunately, I believe you are all aware, Mr. Casavananda passed on the 6th September 2020 at the age of 79 years. The origin of basic structure doctrine has largely been attributed to the Indian Supreme Court decision in Casavananda, with very little or no acknowledgement at all of Professor Conrad's contribution. Yet it is this German scholar who exported it to India. Professor Conrad's theory, which was applied in Casavananda, postulates that there are implied limits on the power of Parliament to amend certain protected provisions of the Constitution called the basic structure. Under Article 368 of the Constitution of India, it is Parliament and Parliament alone that is reposed of the power to amend the Constitution. And indeed, clauses 4 and 5 even explicitly limits the power of the courts to review any act of Parliament to amend the Constitution. No amendment of the Constitution made by Parliament pursuant to the provisions of the Constitution can be called in question in any court in India on any ground. However, in construing Article 368 and the limitations on the powers of the court to question the power of Parliament, notwithstanding, the Supreme Court in Casavenanda held that although the article donates exclusive power to Parliament to amend any provision of the Constitution in accordance with the procedure in that article, the powers could not be used to damage, emasculate, destroy, abrogate, change, or alter the basic structure or the framework of the Constitution. The theory was itself influenced by the Germans' political and constitutional history. Under Article 76 of the Germans' original constitution, called the Weimar Constitution, Parliament had the power to amend the Constitution with the procedural restraints that required two-thirds votes of the members of its parliament to pass an amendment. Adolf Hitler, that well-known but reviled figure in history, used this same procedure, a procedure which is anchored in the Constitution, effortlessly to overhaul the entire Weimar Constitution and arbitrarily took away rights to freedoms of speech, expression, association, and habeas corpus. He then declared a state of emergency. This experience was to inform Germans' constitutional reforms. In their new constitution, the Grand Gazette, the Basic Law, substantive limits have been introduced to the amending power of Parliament. Article 79 of the Basic Law explicitly bars any amendment to the provisions concerning the basic principles like federalism, democracy, rule of law, separation of powers. Our own history is equally replete with the examples and instances that led to agitation for constitutional reforms, as the former constitution was in no better ranking than the Indian or the Weimar constitutions. The former constitution provided for its alteration as opposed to amendment under Section 47 and vested wholly the power to amend it in Parliament, a common denominator with the Indian and the Weimar constitutions. Our Parliament under Section 47, like parliaments of the two nations, could indiscriminately change and did in fact change the Constitution at will in any manner whatsoever without reference to the people. The history of agitation to reverse the trend and save the Constitution leading to the promulgation of the 2010 Constitution is well known and are chronicled in detail in my main judgment. But why is this history important? Just like India and Germany, where the seed of basic structure doctrine was planted, it is their unique history that influenced the path of constitutional reforms and the decision of the courts in those jurisdictions in applying the doctrine. Constitutions the world over reflect the uniqueness and specificity of each society. Even if lessons or experiences can be drawn from those places. In the Kenyan situation, drawing from the past, informed by the present, and focusing on the future, the 2010 Constitution has set up a framework which returns Kenya to the path of democratization. Parliament cannot be used to pass amendments to the Constitution in the manner it did before 2010 because of the current inbuilt mechanisms and safeguards, as well as the complex and elaborate procedures in the Constitution itself. The situation the Supreme Court of India was addressing in Kesavananda is unique to India based on the specific provisions of the Indian Constitution, Article 368 to be exact, their experience, and also based on their history generally. Therefore, in relying on Casavananda, hook, line, and sinker to address the peculiar circumstances of Kenya, the superior courts below ought to have exercised caution and followed the guidelines repeatedly emphasized by this court in various cases, Judges and Magistrates Vetting Board and the Rai case. Courts ought to avoid mechanistic approaches to president because it is inappropriate to pick a president all over the world simply because they appear to provide an answer to a matter at hand. Each of those presidents has its place in the jurisprudence of its own country of origin. There was justification to rely on Casavananda in interpreting Section 47 of the former Constitution in the Njoya case, because at the time our constitutional framework was more or less similar to Article 368 of the Indian Constitution, in the sense that the power to amend the Constitution reposed in Parliament and Parliament alone. But this is no longer the case in Kenya. Throughout the constitutional making process, from the Bomas draft, the Wako draft, the revised harmonized draft, and the proposed draft constitution, it has been made abundantly clear that since the Constitution embodies the will and aspirations of the people, they must be central to its amendment, and that there ought to be a balance to have a Constitution that is flexible enough for posterity and unforeseen needs, but rigid enough to prevent the abusive hyper-amendments of yesteryears. This balance was achieved by clear, unambiguous, and distinct tiered or multi-stage design model codified in Chapter 16, applying different procedures of amendment for different provisions of the Constitution. Specifically, amendment process of any matters in Article 255(1) is complex and onerous. It requires support of 1 million voters, requires the promoters to draft a bill, which then must be verified by the IEBC, and finally, and approval by the county assemblies and parliament, meeting a certain threshold, and finally ratified in a referendum. Attempts to utilize both parliamentary and popular initiatives have failed, essentially because of the tiered or multi-stage design of Chapter 16. You remember the Okoa Kenya Bill 2016, Punguza Mizigo Bill of 2019. To this extent, even the two courts below agree that Article 255(1) embodies the basic structure of the Constitution of Kenya. For me, the most difficult part of the two judgments of the two courts below, and the dilemma flowing from them, is the imprecise scope and extent of basic structure doctrine. Which provision in the Constitution of Kenya, for instance, are not amendable through the procedure in Chapter 16? What does it mean, for instance, when the High Court and the Court of Appeal accept, on the one hand, that all articles in the Constitution are amendable in accordance with the constitutional procedures provided, but on the other, qualifies the statement by declaring that basic structure of that very Constitution cannot be altered using the amendment power in the Constitution? What does it mean when they declare that the basic structure consists of the preamble, the 18 chapters, the 16 schedules? Is it the Constitution is in entirety as a basic structure? Where do Kenyans who wish to propose amendments to the Constitution go to be shown which provisions cannot be amended using Chapter 16 procedure? Do they go to some deity, some oracle of Delphi, for instance? In interpreting the Constitution, courts must provide pragmatic solutions without adding confusion to the controversy that the parties have brought to them for resolution in the first place. Amending the Constitution is not a light matter, therefore, limitations to its amendment must sufficiently be specific and unambiguous. In India today, because of the nebulous nature of implied limitations to constitutional amendment since Casavananda case, every court has attempted to identify by listing some of the essential structural elements of the Constitution that in their individual perceptions constitute the basic structure of the Indian Constitution on a case-to-case basis. Chapter 16 exhaustively sets out the process of initiating an amendment to the protected provisions. Of course, that process includes public participation and a referendum. That is in answer to the question of where is the juridical basis in the Kenyan context for the proposition by the two courts that the basic structure of the Constitution can only be amended through primary constituent power, which must include four sequential processes, namely civic education, public participation, and collision of views, constituent assembly, debate, and ultimately a referendum. The last matter under this ground is to consider the unanimous conclusion by both superior courts below that the proposed amendments in the draft bill amounted to dismemberment of the Constitution. Besides the number of articles sought to be amended, the courts were concerned about the overall effect, that they were so far-reaching in character, scope, and content as to, and I quote, shake the foundation and alter the identity and character of the Constitution as to effectively dismember it. The learned judges variously defined the word dismemberment to mean doing any of the following in the Constitution: unmaking, replacing, disassemble, completely change identity, abolish, tear apart, amputate, and rough mutilation. Do the proposals in the amendment draft bill create a new constitution? Do the verbs unmake, replace, disassemble, completely change identity, abolish, tear apart, amputate, employed by the learned judges to describe the proposals in the bill and to suggest that the proposals were dismemberment of the Constitution, are they so? In my most respectful view, these words were an overkill, and the sledgehammer employed to deal with them was in itself disproportionate. I end this ground where I started. However great, however progressive a written constitution may be, history, experiences, and changes in society would necessitate corresponding changes to the written text of the Constitution, with each generation having the right and freedom to determine the law under which they wish to live. And no generation should bind the course, aspirations, constitutional expectations, values, principles, and objects of generations to come. The language of Chapter 16 is clear and plain, leaving no room for conjecture, inference, or implication. Neither the explicit nor the implicit language of the Constitution, the history of constitutional making, or any principle of constitutional interpretation in this country permits the courts to do what the courts have accused previous parliaments of perpetuating, that is, to undertake indiscriminate and radical amendments to the Constitution by imposing an alien method of amending it. In the result, I would set aside the judgment of the Court of Appeal and hold that to the extent that the basic structure doctrine limits the amendment power contrary to the express terms of Chapter 16 of the Constitution, it does not apply to the Constitution of Kenya, and that there are no four sequential steps for the amendment of the Constitution other than the steps outlined in Chapter 16. The second issue is on the role of the President in the process. This question to me, and of course the question of basic structure doctrine, are the real nerves of this dispute. This particular question seeks to answer the issue of legality, legitimacy, and constitutionality of the process leading to the formulation of the draft bill based on the true construction of Article 257. The High Court was persuaded and declared that the President does not have authority under the Constitution to initiate changes by way of amendment. That a constitutional amendment can only be initiated either by Parliament through parliamentary initiative under Article 256 or by a popular initiative under 257. The Court of Appeal, in a unanimous decision, agreed and affirmed that conclusion. Friday afternoon, March 9th, 2018, which was the same day the justices of the Court of Appeal elected me as their president at Safari Park Hotel, will be remembered as one of the many defining moments in the history of Kenya. It was on that day that, in a move that took many by surprise, the president and his political opponent, Honorable Odinga, with whom he had recently engaged in fiercest and bare-knuckle political contest, met and agreed in what has come to be known as the handshake to end their political rivalry that had been witnessed in the previous elections. The last political contest between the two was so fierce that at the end of it, both laid claim to the presidency. It has been argued that the President and Honorable Odinga, both well-meaning, intended to ease the seething tension and restore peace, unity, and tranquility in the country. To realize this objective and as an understanding of the handshake, the two agreed to pursue a 9-point agenda styled the Building Bridges Initiative, or BBI. A series of events followed, and I traced these events to mark out the role of the President in the process. By a Gazette notice of 31st May 2018, the President appointed a 14-member team known as the Task Force on Building Bridges to United Advisory. By a subsequent Special Gazette notice of 10th January 2020, the Steering Committee on the Implementation of Building Bridges to a United Kenya Task Force report was also established, and as the name suggests, to implement the report of the task force. Of interest, one of its mandate was to propose administrative policy of constitutional changes that may be necessary. The Steering Committee's report was presented to the President on 21st October 2020. It was subsequently launched on 26th October 2020 at Bomas of Kenya in an event presided over by the President. A third entity, the Building Bridges National Secretariat, whose origin is not clear to me, since I have not been able to trace on record any appointment letter or a Gazette notice, appears on the scene. So, co-chaired by Honorable Dennis Waweru, a former member of Parliament for Dagoretti South constituency, and Honorable Junet Mohammed, a sitting member of the National Assembly representing the people of Suna East. On 25th November 2020, at the Kenyatta International Conference Center, the President launched the draft bill and rolled out the collection of signatures to support the initiative. A popular initiative for amendment of the Constitution according to Article 257 is commenced by the promoters getting at least 1 million registered voters to support it. It is the promoters who must formulate the draft bill. They are required thereafter to deliver the bill and supporting signatures to IBC. And from this point, the process is self-executing along the lines in Chapter 16. The term popular initiative has not been defined in the Constitution, but for the present purpose, the definition sources employed by both the High Court and the Court of Appeal are unanimous that the term popular initiative can only be an initiative by the general public. In common parlance, simply the people. The citizen who was described by Madan, Chief Justice in Githunguri, as the man in the market, the man on Pangani bus. On the other hand, the word promoters in the Constitution is used only in Article 157. It is apparently a term of art in the context of amendment of the Constitution, describing the persons not in the company law sense or in the colloquial sense, but those who initiate or champion constitutional changes. Beside the definition of the term popular initiative, there is history behind the process for the intendment of the framers. The CKRC final report 2005 acknowledged and recommended that apart from Parliament, it was necessary for the people, in brackets, citizens and civil society, in exercise of their constituent power, to be involved in the constitutional changes. The term popular initiative originated from this report. With that history in mind, there cannot be any debate as to the target of Article 257. It is the people. The suggestion that Honorable Waweru and Honorable Mohammed, as co-chairpersons of the Secretariat and not the President, were the promoters cannot be accurate. First, the Secretariat emerged, as I've said, from the blues, as it were, for the first time in the process. However, Honorable Waweru himself, on behalf of himself and the co-chairperson, swore an affidavit of 5th February 2021 to state that the Building Bridges to a United Kenya was created and mandated with the task of initiating a constitutional amendment process and unifying Kenyans, among other roles. That the task force and the Secretariat conducted a robust nationwide public engagement and collection of views, and that from these views, it made various legislative, policy, and constitutional amendment proposals in various fields affecting Kenyans. So that, although the Secretariat does not disclose its origin, its ancestry, its family tree, its gene cannot be concealed. The affidavit says it all. The great-grandfather is the handshake, the grandfather is the task force, its father is the steering committee, and the surname of all of them is Building Bridges Initiative, alias BBI. The bill which the Secretariat presented together with the signatures to the IEBC was clearly, so to speak, inherited from the steering committee, almost a replica of the bill annexed to the steering committee's report to the President. The draft bill was curiously signed by Building Bridges Initiative as the promoters. and not Honorable Waweru or Honorable Junet, or even the Secretariat. It's not clear how they went about collecting the signatures, but on record, at least, there is some evidence of state involvement, going by the letter written by the Principal Secretary, State Department for Sports, directing the Director General, Sports Kenya, to supervise the staff in the organization to complete the forms and sign appropriately and urgently the forms. The conclusion I reach, as should be apparent on the first limb of this ground, is that the President, as a matter of fact, commenced and spearheaded the process from its inception and only passed on the baton to the two co-chairpersons when it was too late in the day and beyond recall. That the President is ineligible to directly or indirectly initiate a constitutional amendment to the Constitution under any of the prescribed circumstances. That he cannot act as an ordinary citizen because he is not, and at the same time claim to be exercising executive authority. He cannot, in the circumstances of Chapter 16, run with the hare and hunt with the hounds. It has been argued that by barring the President from initiating the process of constitutional amendment, his right to equality and freedom from discrimination would be violated. The nature of violation has not been demonstrated. Looking at the facets of the rights and fundamental freedoms under Article 27, I cannot see any that could be breached by simply asking the President to stay on his lane of constitutional amendment process. Similarly, the guarantee of his political rights, which are specific under Article 38(1), that is to make political choices, to be registered as a voter, and to vote by secret ballot in any election or referendum, violated. The President's role in the constitutional review process has been preserved and is intact. The power to assent to a draft bill passed by Parliament and to request the IEBC to conduct a national referendum for approval of the bill are indispensable roles and essential cogs in the process. Apart from these, the President, as indeed any other voter, is entitled to support a popular initiative by signing it, and in fact he did so in public. Indeed, nothing stops the President from campaigning for or against the initiative. For these reasons, I agree with the learned justices that to the extent that the President took certain steps and actions at the inception of the popular initiative process, as explained, the entire process was irredeemably flawed. I would, in the result, affirm the conclusion of the Court of Appeal. The number of constituencies today, by dint of Article 89(1), stands at 290. The superior courts below were unanimous, and I am in agreement with them, that Article 89 is amendable in accordance with Chapter 16 to increase or even decrease the number of constituencies as proposed. The quarrel with the second schedule relates to paragraphs 1, 2, and 3 of the draft bill. After delimiting the constituencies for the National Assembly to 360, an additional 70 constituencies, the schedule sets out the manner and the period of review of the names and boundaries of those constituencies. This task, in terms of the Constitution, is donated to the IBC, the period being at intervals of not less than 8 years and not more than 12 years, but on condition that any review must be completed at least 12 months before a general election of members of parliament. Furthermore, if a general election is to be held within 12 months after the completion of a review, the new boundaries cannot be used in that election. The second schedule went against Article 89 and all that I've said by providing only for a single criterion, the population quota, as the basis for delimitation. It went ahead and distributed the newly created 70 constituencies to specific counties. It directed the IBC to delimit the boundaries on the new constituencies on the single criterion. It ignored the irreducible constitutional consideration and the existing scientific criteria in Article 89. And finally, it ignored the principle of public participation. In view of the foregoing, the inescapable conclusion is that I'm in respectful agreement with the learned justices of the Court of Appeal that the second schedule to the bill was inconsistent with the Constitution, to which extent it was correctly so declared. I would reject this ground of appeal. The fourth issue is on presidential immunity. In his petition, Force 26 of 2020, Isaac Alochier versus Uhuru Muigai Kenyatta, Mr. Alochier asked the court to determine whether the president can lawfully initiate a constitutional amendment through a popular initiative process, whether the president can establish a steering committee, and whether the steering committee had locus standi to promote constitutional changes pursuant to Article 257. It also sought from the court to determine whether civil court proceedings can be instituted against the president during the tenure of office in respect of anything done or not done in excess of powers donated by the Constitution. Before us, while highlighting his submissions, Mr. Alochier complained that the two superior courts below made pronouncements that were wider than his original prayers, where he had only sought a declaration that the president had acted outside the functions of his office by unlawfully establishing the steering committee, for which he ought to have been held liable. The Court of Appeal, having arrived at the conclusion that the president was not heard in his defense on allegations of breaching Chapter 6 of the Constitution, it was moot to consider whether the president was properly sued in his personal capacity, all the orders made against him in that capacity having been set aside. Consider, too, that both courts nullified the popular initiative on the ground that the president was not qualified qua president to initiate it, confirming that his actions, the gazette notices and so on, were official. Mr. Alochier's question was effectively answered, that no civil proceedings could be instituted against the president in his personal capacity in respect of his role in the proposed amendment. That would have been sufficient to conclude this ground. I cannot agree more that the route taken by the High Court and the Court of Appeal in responding to Mr. Alochier's contention was respectfully slightly overboard. Their determination of the matter in the manner they did has, however, presented a chance to this court to express itself directly on the question for the first time. Under Article 131 of the Constitution, the people of Kenya acknowledge the immensity and enormity of the office, and declared that the president shall not hold any other state or public office except that of the president. Again, because of the exerting nature of those responsibilities, the Constitution grants the president immunity to enable him or her to discharge the functions enumerated above with as much freedom, flexibility, and peace of mind as possible. Because the President's actions while in office are actions of the state and not personal, any person who is aggrieved by the exercise of state power by naming the Attorney General as a respondent in a judicial review application or a constitutional reference, or secondly, to institute civil action at the end of the President's tenure, because Article 143.3 holds the time